Case number 23014-959, CB.
Mr. Kashev, good morning.
Good morning, Your Honor.
Morning, Your Honor.
Good morning, Mr. Ojoba. All right, you guys, I assume got my email yesterday on the non-emergency emergency motion.
Did
I'm not sure where to even start, guys. Mr. Kashev hasn't responded. I've
I
read the
have
motion.
I have responded, Your Honor. I filed one at about 4:30 last night.
Yeah, well,
But
you might work after hours, but usually I don't, so I haven't seen your written response. So all I know, look,
I can,
you can tell me in 10 words or less, but I'm going to let Mr. Ojoba go first. It's his
sure.
motion, but I did read the motion. There's some chicken scratch that I can barely even read legibly that purportedly evinces an agreement. Then it looks like the lawyers got involved, and per usual, something went south, and now there's not a meeting of the minds. I'm not cleaning up the mess, guys. Just not. But Mr. Ojoba, with that preamble, go ahead.
Yeah, Judge, I'll try to be brief, and I understand that it's frustrating to have that written down the way it was. It kind of sends back memories of the writing on a napkin from law school.
Exactly.
But Judge, the right context to this case is as you know, or you may recall, Your Honor, we've met several times with Mr. Bullock to try to resolve the case. I'm not sure if the court's aware of this. We had a 14 and a half hour session with Tom McNeil. And I don't want to take the court's time. I'm not going to assign blame. We just couldn't get it there. But to my surprise, and I was totally unaware of it, and I don't believe brother counsel was aware of it, the parties did meet. And here's the salient point.
They just for context, they met without the lawyers, right?
Right, but they met with somebody, an industry guy. That's the salient point, and it's somebody that they both know and they both trust. And Your Honor, while I can't disagree with you that there are parts of the document that's attached to my motion that are chicken scratch, the material parts are very clear cut. And just for the record, if you'll allow me, Judge, I'll be quick. I want to go through just a couple of the points very quickly. The claims and the counterclaims in this case, every single one of them have been addressed by this agreement. Every single one of them. And more importantly, Judge, the document that we believe is an enforceable settlement actually states that Hatem Hamawi will be a mediator and an arbitrator. They want out of court and they never want to return to court. For example, we say Buttress owns 0. That's our claim. We've resolved it. He owns 50%. That resolves our case. He says shareholder oppression. We kicked him out. He's not on the bank account. The document says he's 50%. He's on the bank account, et cetera, et cetera. The issue arose, Your Honor, one other very important point. The parties performed under the agreement. After the agreement was signed, there were no objections from anybody. There were actually text messages between Hatem and the two parties regarding the electrician, regarding construction, regarding getting together. Where it broke down, Your Honor, I know you have a full docket, so I won't totally get into it. Where it broke down is after I sent the attached document, lawyers get involved, and I'm not going to assign blame, but I believe from our perspective, there was language and terms that went beyond the agreement, but set that aside for a minute. They're all hypotheticals. They are not issues in this case, and set that aside for a minute. Hatem Hamawi is the one to decide those. That's the salient point. I have no doubt, Your Honor, that from a legal point of view, we had a meeting of the minds. There's no allegation of fraud, duress, mistake. And the only thing that I would suggest, Your Honor, if the court is not inclined to grant my motion at this time, is to order the receiver to take that document, look at it, and draft a more formal settlement agreement. So, Your Honor, in short, I would just ask the court to grant my motion to enforce the settlement.
Well, I want to hear from Mr. Kesh in a second. First of all, look, I appreciate that the parties finally have gotten together and apparently have had some meeting of the minds. And, is the breakdown the lawyers? Somehow the client's not getting all the terms? I don't know, but I can't even read what you've submitted here. Deadlock, provision. Haddam, any issues of deadlock, Haddam will be, I mean, this is, I can't make heads or tails of that. I can't even begin to start to, and that's why we have lawyers to effectuate the intent. But anyway, Mr. Kashev, go ahead.
Thank you, Judge. Look, there are numerous components of this document that are vague. It is a term sheet, Your Honor. It is an absolute term sheet. The document itself says there will be drafted documents after this that need to be drafted. Amended operating agreement is referenced twice. It doesn't say in the manner in which the operating agreement needs to be amended, but it says it needs to be amended in the future. It says the parties will agree in the future as to what their capital account values will be. There is vagueness throughout the document with respect to the manner and how much capital needs to be put into the development of a cannabis facility. No doubt these individuals sat down. No doubt they are currently represented by counsel. There's no question that they've spent tens of thousands of dollars in lawyers to enter into a settlement agreement without their lawyers being participants in that process is just a ridiculous concept. There's no reference to releases in this document. There's no reference to the dismissal of the lawsuit. The document itself doesn't say it's a settlement agreement. It is a term sheet that has vaguenesses that needed to be worked out between the parties and counsel. The law is clear. If 85% of this is clear and 15% is vague, the whole document is a non-settlement agreement. The entire document, all terms need to be agreed upon for it to be an enforceable settlement agreement. That's the Dabish case that Mr. Abdrabo referenced. I was the lawyer on the Dabish case. I was the one who was able to successfully enforce the settlement agreement that got reversed by the Court of Appeals. In this situation, as I write out in my response that the court hasn't seen, there are at least a dozen areas in which the document says we'll draft future documents, we'll reach future agreements. They don't even address various disputed issues between the parties. Where we're at, Your Honor, we have a trial scheduled for September 15th. I drafted the final pretrial order weeks ago. I sent it to Mr. Abdrabo, and I respectfully asked him, just give me your components. You're the plaintiff. Give me your components to the final pretrial order. I've gotten no response, although that final pretrial order is due on Monday.
Because your client wants to settle the case.
For sure. I'm working on two fronts. I'm doing my job. You have an order, Judge, that says that 21 days prior to trial, I, as the defendant, which I find odd, but as the defendant, I need to draft the first draft of the final pretrial order. That was due 21 days before trial. I'm doing my job. So I did that, sent it to Mr. Abdrabo. At the exact same time, I'd love to settle this case. We're about this far away. If you look at his motion, the things that he says are not settled upon, my latest draft, we're so close, Your Honor. So close. But Mr. Abdrabo won't return my calls. I called him twice.
Mr. Kashev, I don't know that you reading the court. I sent an email yesterday. You both got it.
Yeah.
I've made comments on the record. You're arguing as if I don't agree with you. It's not a settlement.
I know.
It's not a settlement. It's not a settlement agreement. There are things that need to be worked out. I can't enforce this chicken scratch, and I don't mean that. Well, there are terms that need to be worked out. I can't read half of it. There's really nothing this court can do. The lawyers have to sit down and hammer out both the major terms, which appear to be here, but there are some details that need to be worked out, and I'm not going to do it. It's not my job.
Your Honor.
And now I let the record reflect the receiver has popped in. I know you're here on another case, Mr. Bullock, but
I am, Your Honor. I'd like to make a suggestion. I'm willing to spend my weekend doing shuttle diplomacy between both sides. This weekend, we got a trial coming up. This weekend, if the lawyers will commit to getting their clients available or making them available, we'll do it telephonically, and we will work through these agreements if it's possible.
You guys do. I can't order it. You guys do what you want to do. I think that's a fantastic idea, but I think probably Mr. Kashev and Mr. Objoba could sit down and write this out.
So what I wrote in my response, Judge, is that
go ahead.
given the I'm sorry.
No, go ahead. Sorry.
Given the timelines that we have, my request and my response is to dismiss the motion. We need to be compelled to meet. Mo and I need to meet to prepare the final pretrial order, which is due on Monday. You said the last time we were before you, you weren't going to move the trial date under any circumstances. I took that to heart, Your Honor. I respected the court's position. So, and I believe that that is what is helping the parties get some sense of reasonableness.
Has it come to this in the, has it come to this in the practice? I mean, look, both you guys been around a long time. You know what you're doing. I have to order you to sit down to do what I've ordered you to do.
I don't know, Judge. I'm just trying to get
if he doesn't do what he's supposed to do, well, there are remedies for that, but I'm not going to order him to do what's already been ordered to do. That's silly.
So then
I haven't done, again, this is just another, there hasn't been a deadline that's passed. You're complaining about something that's due September 8th. Your Honor, the problem here is that.
But hold on. On the other hand, it's due the 8th. You can't give it to him September 7th. It's September 4th. It's Thursday. When are you going to
I understand, Your Honor, but there's been multiple tracks, as you're aware, and I mean, again, the court's going to make its ruling, but the effect of the ruling is not just to deny the motion; it's to deny the hours of meeting and the written document and a meeting of the minds. And you're asking us to negotiate. How does my client go sit and negotiate from scratch? There are material terms in this agreement. And Your Honor, if it's chicken scratch, order the receiver to type it up. And let's start with that. Have him fill the gaps. The court can have a trial on whatever is allegedly missing in that agreement. I mean, there is not a single issue that isn't resolved that's not a hypothetical. Everything's a hypothetical.
Here's my diagnosis, and I said it in the email yesterday, and I'll say it here on the record. The clients got together. They did their part. There's a vibe about this case. These clients have been at it for 2 years now. I think we need other lawyers to get involved, to get reasonable, to sit down and craft an agreement. My diagnosis at this point, the lawyers are in the way of the settlement, not the clients. And it shouldn't be like that, because I know both of you, you're both good litigators, great attorneys. I can't understand why you can't get a settlement agreement crafted. I don't understand it.
Judge, I could screen share the last version that I sent to Mr. Abdrabo, which is his version with maybe 4 edits from me. So you could see, Your Honor, out of a 7-page settlement agreement that Mr. Abdrabo drafted and I revised, the issues that remain are minuscule. I don't want you to think that and Mr. Abdrabo was making it seem like we're so diametrically apart. It's absolutely not. It's all black letter.
Then if they're minuscule, get off my Zoom, get on a call with Chuck Bullock or yourselves, and work through it.
Yeah, thank you, Your Honor. I'm available this weekend. I mean, it's just lawyers talking over each other. So I'm available this weekend. If not,
you guys all know what you're doing. You can get it done. The only thing I'm going to do is keep up the pressure with the trial date, and either we're going to have a trial or we're going to have a settlement. I'm confident we're going to have a settlement. You guys got to work out. If they're minuscule, they're minuscule. If they're not minuscule, you still got to work them out. But I can't enforce anything. I'm not granting an emergency motion, not adjourning the trial. I'll wait to hear, Mr. Bullock, if you could report to me by Monday what your efforts have done.
I will, Your Honor. I will.
I'd like an email with Mr. Abdroba and Mr. Keshev on it so that I know we're close, we're not close. I need to seal the deal on a couple of issues. I'd be willing to do that next week, but.
Yes, sir.
All right. Okay. Formally, for the record, the emergency motion's denied.
Thank you, Your Honor.
What else, Kevin? Is that it?
No, that's it. That's it. We'll get it done, Your Honor.
All right, guys. Peace out. I'll look for your report Monday, Mr. Bullock.
Thanks, Judge.
Thank you, and I appreciate that.